Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Listen, for those of you who routinely geek out here on the channel, you know that we've been doing a bunch of videos as it relates to the ongoing war, some of it very obvious, some of it behind the scenes, against the FFL industry. Along comes a really interesting case. It's one you're not going to hear very often. It comes out of Pennsylvania. And it's the ruling that has me most concerned. So I want you all to kind of imagine for a second kind of a doomsday scenario for the FFL industry, because it might look a little something like this. So today, let's spend a few minutes and let's talk about, what if the Second Amendment didn't protect gun stores? Okay, so the case we're talking about today is United States v. King. Never heard of it? Yeah, neither had I. What is United States v. King? Well, United States v. King is a case that comes out of the U.S. District Court in Pennsylvania. Mr. King, an Amish gentleman, is accused and has been found guilty now of selling thousands of firearms without ever obtaining an FFL license. Now, he was only convicted of a single count of this, but the allegations were that he sold thousands of firearms, including many to undercover federal agents. Now, Mr. King, who I mentioned earlier is a member of the Amish community, claims that his religious beliefs prohibit him from being photographed, and a photograph is necessary in order to obtain an FFL, and so Mr. King felt it best that he just go alone and do it without the FFL. Unfortunately, the United States government did not agree with that. Now, here's the thing I want you to be aware of, okay, and this is the thing that everyone needs to be concerned about, it's the reasoning of the court, because you see, when the government filed these charges against Mr. King, his attorneys filed a motion to dismiss claiming that the statute was unconstitutional. And what they claimed is that when we take a look at the Bruin historical analog test, there is no historical analog going back to the late 1700s that show that there is a tradition of regulating those who sell and trade in firearms. And if you really want to get technical about it, it's true. Because really the first formation of any type of federal regulation on the sale of firearms took place in 1934 with the creation of the National Firearms Act. But here's what the court said, because as we know under the Bruin test, okay, the test is if the plain text of the Second Amendment covers the activity, then the government must demonstrate a historical analog to show that we as a society accept that type of regulation. What the court ruled here is, hey, it doesn't even survive. The activity of selling firearms does not even survive the first part of the Bruin test, or essentially that the Second Amendment does not protect the selling and commercial transaction of firearms. As the court ruled, if the Second Amendment's plain text covers certain conduct, then the government may regulate that conduct only by demonstrating that the regulation is consistent with the nation's historical tradition of firearm regulations. Contrary to King's argument, the court did employ that analysis in its prior opinion. It simply never discussed the second part of the analysis because King's conduct did not make it past the first part. In other words, the Second Amendment's plain text does not cover the commercial sale of firearms. As a result, there is no need to discuss whether the act is consistent with the nation's historical tradition of firearm regulations. Now, this ruling, which is a terrible ruling, comes at one of the most inopportune moments in American history when this particular administration is hell-bent and absolutely on a warpath against the FFL industry. And we have done this video right here, which talks about how the current state of the ATF is such that they could literally shut down any FFL in the country just like that for a simple clerical error. So this, as we know, every time there is a new liberal civilian disarmament theory advanced by a court, such as the common use for self-defense test that we're seeing now, we will see other courts begin to latch on to this. And so other challenges to the commercial sale, regulation of commercial sale of firearms, and all of the other shenanigans going on with the FFL industry could likely be met with this ruling that, hey, you know what? The Second Amendment protects the right to keep and bear arms, but it doesn't speak to the commercial sale of firearms or how a person obtains firearms. Now, we could go through, and I know in the comment section you guys are going to blow it up with this is ridiculous because how can a person exercise their right if they can't even access it? You're all correct. You're all correct. But as we also know, none of these arguments will ever stop those that are hell-bent on civilian disarmament. As the court ruled here, King is alleged to have violated the Gun Control Act by engaging in the commercial sale of firearms without a license. That conduct is not protected by the plain text of the Second Amendment. The act does not stop King from keeping or bearing arms. The act does not keep him from buying and selling firearms in order to maintain a private collection. Nor does the act prohibit the commercial sale of firearms outright. It simply requires a license to do so. As a result, the act does not violate the Second Amendment. And of course, the act he's referring to is federal legislation that mandates that anybody who is selling firearms actually have an FFL. We understand that there's more appeals coming, and so we will keep our eyes on this. But for everybody in the FFL industry, and then for all the rest of you who are very dependent upon the FFL industry, there is now a ruling out there from a federal court that says that the Second Amendment does not cover the ability to purchase firearms. So you need to be aware of it because yet this is another tool that they're going to use in their goal of complete and absolute civilian disarmament. Listen, if you have any more questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to contact Washington Gun Law by now. If you don't, that's okay. That information is down there in the description box. In the meantime, I do want all of you to remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.